This lecture is about state of mind issues which occur in evidence problems. Now, there are three circumstances where these issues come up. One is where I declare to you what my state of mind is, and now you are called to testify to what I said about my state of mind, for the truth of what I said about my state of mind. That obviously creates a hearsay problem, and there are some issues around that hearsay problem that we need to be able to deal with. The second circumstance is where you create my state of mind. For example, you say to me, Emerson, I am going to stab you with this knife right now. And that's going to create a state of mind in my mind. One state of mind that will create is the need for self-defense. And the rule is, for deadly force, the rule is that I can only use deadly force if I reasonably believe that deadly force is necessary to prevent immediate great bodily harm or death. Now, I have to reasonably believe that. But if someone does what I just mentioned, that would create that state of mind. And if someone testifies to what the person did who was about to kill me, they're not testifying to what that person said and did for the truth of it. They're testifying for the impact on me, the hearer. Someone might yell to me, "Look out!" Now I have notice. Someone might say to me, "I just killed your favorite cat on purpose." Well, supposing I had a favorite cat and this person did this and I was upset about it, that might create anger. And so the second set of circumstances, first set of circumstances is where I declare what my state of mind is and someone's going to testify to it. And the second one is where you cause my state of mind, and the words that you use to cause my state of mind are not offered for their truth, they're just offered for their effect on the hearer. And the third situation that we have to be ready to analyze is the one where there are circumstances such that you figure out what my state of mind is. For example, if I'm standing on the corner at the traffic light in the rain, cold, with no clothes on, directing traffic, saying, "I am Napoleon, join me in the war." Now, you will know that I'm crazy. If you testify at my sanity hearing, you're not going to testify that Emerson said, "I am Napoleon for the truth of the matter asserted." That's just part of the circumstances. All those circumstances together, including my words, are the circumstances that led you to believe that Emerson is crazy. And so the third situation regarding these states of mind are where you figure out my state of mind by words and circumstances. And again, the words that are used there are not used for the truth of the matter asserted, but to show that I'm crazy. So those are the three situations that we want to be able to analyze at the level of depth that we need for the bar exam, and let's talk about those. To do that, let me first talk about this whole hearsay problem, because that's the one we're going to talk about first. And we need to look at some of what we're trying to do in this hearsay in order to really understand it well. Let's suppose that this is a person who is in court and there's a witness on the witness stand. And at court, what you want from this witness is information which is reliable and trustworthy. Now, when we say we want reliable information from this witness, we are talking about the correctness of the information. We want correct information. Did the witness have a chance to observe whatever it is they're testifying about clearly? Do they remember it well? Did they forget some parts of it? Did they write it down? If they wrote it down and brought it to court with them, did something happen to it along the way? All this reliability stuff is about the correctness of the information that the person is about to give you. And hearsay would be, in that category. The second thing that you want when the person is on the stand is trustworthiness, and that is asking the question, is the person trying to tell you the truth? So the first one, reliability is correctness. Trustworthy, is the person trying to tell you the truth or not? And if this person is on the stand in court, the lawyers go at it and try to, establish, well, is the evidence reliable enough, and is this person trustworthy? So they do that. Now, let's change this. Let's suppose that I'm on the stand, and I'm on the stand, and I say, my leg hurts while I'm on the stand. Well, what the court wants is reliability and trustworthiness. Reliability is the correctness. Well, I certainly am the best person that knows whether my leg hurts or not. And so that's about as reliable as you can get. You can't, I may not be trying to tell you the truth about it, but in terms of the correct information, I do have the correct information because I know whether my leg hurts, my stomach hurts, I feel good, I'm happy, whatever. So it's reliable in that sense, it's correct, but I may not be trying to tell the truth, and that's the trustworthiness part of it. But the lawyers go at that, and so if I'm on the stand, that's what they do. But now suppose I am not on the stand, and I'm not on the stand, and the same issue comes up, here me, and I say my leg hurts, and I tell you that out of court. And now you take the stand, and you're testifying. Well, from you, they want reliability and trustworthiness. Well, the reliability is asking, are you correctly repeating to the court what you heard from Emerson? And are you trying to tell us the truth about whether or not you are correctly repeating what you heard? You're not really dealing with the content. And so you get the reliability and trustworthiness of you on the stand, but that doesn't get to this part of the problem, the person who actually made the statement. So to get reliability and trustworthiness at this branch, you're going to have to look at these circumstances and say that in those circumstances where reliability and trustworthiness is kind of built into those circumstances, then we may have a hearsay exception for that. If I say my leg hurts to you and you are a medical person and I'm trying to get medical treatment, I'm probably telling you the truth because I want good medical care. Reliability, well, I'm the person who has the best information about how I feel. So it would kind of be built into the circumstances if you are a medical person. If you are not a medical person, then if I say to you, my leg hurts, then, this needs to be under circumstances where, I'm not just making it up for the court or something. The judge would look at the circumstances under which I said that. And if I said my leg hurts 2 days after the accident, I say my leg hurts, gee, it must be broken. Well, that sounds like a sincere statement. If it's something that sounds like it was made up for court purposes, then we'd have this issue. Trustworthy, reliability, I know I have the information. You also have some necessity here. The reason you have necessity is because really, if you want to know how my body feels for some reason that's relevant in this court proceeding, I am the best person to tell you that. In fact, you're not going to find out how my leg feels without me telling somebody, okay? Because you can't put a meter on my leg and tell me how it feels. And so I've got to tell somebody in order for you to get the information. And if I tell somebody out of court, and I can go to court and tell the court, but then I might be saying, 2 years ago when the accident happened, my leg hurt then. Whereas if I said it to somebody at the time of the accident, that's probably a more useful piece of information. So in any event, you have some necessity here. So I say my leg hurts, the reliability is there, trustworthiness may or may not be there, the judge will have to decide. And if you have enough reliability and trustworthiness and got some necessity, then you should be able to testify to what I said for the truth of what I said. Now, keep in mind that when you do this, we view this as me declaring to you my state of body. If I declare my state of body or my state of mind to you, that's what this exception is about, 803 sub 3. Declaring my state of body or declaring my... Well, if I say to you, my leg hurts, that's declaring my state of body. If I say to you, I'm happy, that's declaring my state of mind. And so they're both in the same code section because really it's the same set of policies. I'm the person who knows my state of mind best. I'm the person who knows my state of leg, and so forth. So if I say to you, I'm cold, that's the same thing as the same kind of hearsay issue. If I say I'm cold, It's the same situation as saying, I'm happy, or I'm sad, or whatever. And so declaring my state of mind and declaring my state of body are both, you have the same declaration of state of mind and body exception to the hearsay rule. But what you need to watch out for is that if I want to go this far, I want to say, well, what about this? Suppose I remember something from the past. And now I say to you, well, my state of mind right now is that I am remembering something from the past. Now, this is different from my state of mind is that my leg hurts, or I feel happy, or I intend to go kill Joe or something. That's a state of mind about stuff that's going on right now. But if I'm saying, well, suppose my state of mind is remembering something from the past, and then the point is that the hearsay exception does not apply to that state of mind. That if my state of mind is remembering stuff from the past, then that's the hearsay exception doesn't apply to that. It applies to the activities in my mind going on right now about my leg, my body, my feelings, my emotions, and so forth. Secondly, what about my beliefs? I mean, I can have a state of mind that, I believe something. I got a belief system or something. Well, if I believe something, that again is not like my leg hurts. See, I'm happy, I intend to kill Joe, I'm sad, I like somebody. Those are all present active states of mind, but when you start talking about I believe so-and-so, I have a belief system, a belief about, that's not that same sort of thing. So the hearsay exception doesn't apply to beliefs, it doesn't apply to remembered events, it applies only to the state of body and the present active state of mind. So now with that in mind, let's take a look at how we deal with this formally. The hearsay exception, there's a hearsay exception, this is 803 sub 3, for out-of-court words which declare one's own present state of body or mind offered to prove the truth of what the words say. Now let's talk about this for a minute. First of all, a hearsay exception for out-of-court words, and I want to clarify here that what I really mean is an out-of-court statement, okay? And the code defines 801 defines a statement as either an oral statement or a writing statement or conduct that was intended to convey a message. Like if I point the finger, nod the head, shake the head, that sort of thing, that is conduct that is intended to convey a message. But if I'm running away from the scene of a crime, you may interpret that to mean something, but I'm not trying to tell you anything. So that conduct is not assertive conduct, whereas pointing my finger or something is assertive conduct. So what the rule really is over here is it says hearsay exception is for an out-of-court statement, actually, which declares one's own present state of mind. Now, if I declare somebody else's state of mind, you get that situation where I say, I'm going to meet Mary at the movies. And so I'm declaring my state of mind because I intend to do something in the future. But I'm also saying Mary intends to meet me there. And so I'm declaring both of our states of mind. And this rule is about my declaring my own state of mind, not me declaring Mary's state of mind. Okay? And the advisory notes at the federal rule from the House of Representatives advisory note says that we do not intend for this to apply, this exception to apply to the declaring somebody else's state of mind, only the declarant's own state of mind. Now, some states treat that differently, by the way. Some jurisdictions, that's the Hillman doctrine, basically, mutual insurance company versus Hillman. And some jurisdictions, if I say, I intend to meet Mary at the theater, some will apply Hillman to that, some won't apply Hillman to it, and some will apply Hillman to it only if there's some additional evidence that Mary actually met me there. Okay, but getting back to our federal rules, the federal rule says you got to declare your own state of mind, and it's got to be your present state of mind, not something you remember and not something you believe. Offered to prove the truth of the matter, what the words say. So if I say, I feel cold, I say that to you, I feel cold, I'm declaring my present state of mind, then that is, you can testify that Emerson said he feels cold, and you're offering that to prove I actually feel cold. Okay? If I say to you, I am confused, and you testify, you're offering that to prove that I am in fact confused. Not just I said it, but offering it for the truth of the matter asserted. I am confused. Now, this hearsay exception then is for out-of-court words which declare your own present state of mind, and those words are offered to prove what they say. I am cold, I am hot, I am happy, I am whatever they are. Here are some examples. I intend to kill your cat. That's declaring my present state of intent to do something in the future. I'm going to get even. Same thing, declaration of present intent to do something in the future. That's a present state of mind. My leg hurts, present state of body. I intend to remain in Utah. That's declaring your present intent for domicile purposes. If you're in Utah and you intend to remain there, you're now a citizen of Utah, domicile. And so you declare that intent here. I am lost. Same thing. That's declaring your present state of mind. Can't use it for belief and you can't use it for memory, things that I remember, that state of mind from remembering stuff, the exception does not apply to them, and the state of mind created by your belief does not apply. Just these kinds of things. So that takes care of our first state of mind, and that is the one where there is I tell you what my state of mind is, and you want to testify to it. You can do so, and that testimony will be offered to prove the truth of what I said. Now, let me point something out here to you, and that is that there's a relevance issue that often comes up here. For example, if you can establish that there was a point in my mind, there was a point in time when in my mind I really intended to kill Joe. Okay, if you can prove that, establish that, I intended to kill Joe, because if you can establish that, that is relevant on the question of did I really kill Joe? And so if I say I intend to kill Joe, then there's two issues that you need to write about that on the exam. One is that it is relevant because if I really intended to kill Joe, that's relevant on the question of did I do it? And secondly, can you get that evidence admitted for its truth that I really did intend to kill Joe? You need the hearsay exception, and that's how you use it. So you have the hearsay exception and the relevance to talk about. So that takes care of the hearsay exception. Now let's take a look at out-of-court words offered for their effect on the hearer's mind, not for the truth of the matter spoken. So those are not hearsay. Examples, we talked earlier about threats. Someone makes a threat against me, that's likely to create a reasonable belief that I need to use self-defense. Someone says, you have bad brakes. Well, now you're on notice that you got bad brakes, and it's a different state of mind than if you didn't know that, because you're probably being reckless now, whereas when you didn't know you had bad brakes, you're probably just being negligent. I just killed your cat. Assuming you love your cat, this may create anger. So we're talking about cases where you don't offer the statement, I just killed your cat for the truth of the matter asserted. You offer that to show its effect on the hearer, namely anger. The you have bad brakes is not being offered to show that the brakes really are bad. It's offered to show that the person driving the car had notice. I'm going to hit you. Well, that creates apprehension in the person who said that. And if you got the apprehension, you got the statement, I'm going to kill you, and you got some circumstances where I'm going to hit you even. You got some circumstances where it looks like it's going to happen. You may have enough apprehension to get a civil assault out of that. But in any event, these words are creating states of mind, and the key point here is that these words are not hearsay because you're not offering them for their truth, you offer them for their effect on the hearer. Now the third situation we need to analyze is where out-of-court words are offered as a part of the circumstantial evidence of the declarant's state of mind, such as insanity, confused, angry, and so forth. For example, as I mentioned in the introduction, if I'm standing on the corner naked in the rain, cold, directing traffic, telling people I am Napoleon, well, that totality of circumstances is evidence that I'm crazy. And so and nothing there, the words I said are not being offered for their truth, they're being offered as part of the circumstantial evidence I've lost my mind. And that can happen, God told me to do it. Again, this person who says that, you're not offering that for its truth, you're offering that for the fact that you're trying to establish an insanity defense. Person is loudly cursing about something. Well, that person, what they say during their cursing, may or may not be admissible, but the point is that their words show that they're anger. And so you can look at words and circumstances and often deduce somebody's state of mind from that, but the words that they use may not be offered for their truth, just the fact that it shows that they're angry. Now, so that's how that whole system works. We have three things we need to be aware of. One is if I declare my state of mind, my own, not somebody else's, if I declare my state of mind to you, that you can testify to what I said. It's got to be relevant, of course. If I said to you, I'm cold, and the crime or lawsuit has nothing to do with that, then it's not even relevant. But if I say to you, I intend to kill Joe, then that's relevant. If I really did intend, that's relevant on the question of did I kill Joe? And so you got relevance, and then you got a hearsay exception that we just talked about. The second is where words or conduct that have an effect on the hearer, that create a state of mind that the hearer has. And then the third set of circumstances is where you literally figure out what somebody's state of mind is by the words and circumstances. Now let me give you three quick examples, or 3 or 4 quick examples of how this has been tested in the past by the bar. And I call your attention to, let me get my glasses. In the July 2000 California bar exam question, I'll read you just a part of the question that deals with this area of law. It says, the prosecutor called Wolf, a patron at Guy's bar, who testified over defense objections, that Dan told him the night before the alleged sale that Dan intended to sell some baggies to Peters the next night. Well, there is Dan declaring his present state of mind, intent to do something in the future. And that's what you were expected to deal with there. Another example, July 04 bar exam. Tom, an acquaintance of Daniel, testified for the prosecution that Daniel has complained to Tom that Victor had burned him several times and stated that he, Daniel, would burn him one of these days. Well, there's your declaration of present intent to do something in the future, and that's the exception you were expected to deal with. Another bar question. Rumi, Vicky's roommate, testified for the prosecution that Vicky told her, as Vicky was leaving their apartment on the night of her death, quote, Dan and I are going to see The Graduate at the First Theater, close quote. Well, she's declaring her state of mind to go there, but she's also declaring Dan's state of mind. And under the federal rules, this hearsay exception does not apply to her declaration of Dan's state of mind. It applies only to hers. Some jurisdictions will let that in. One last example. This is an example where Don is claiming self-defense in a fight. So Don claims that Vic started the fight and that he, Don, drew his dagger only when he became afraid that Vic was going to beat my brains out and kill me. That's what Don testified. Then Don further testified. Because obviously Don is claiming self-defense. Now, if Don is claiming self-defense, Don has to establish that he had a reasonable belief that deadly force was necessary to prevent great bodily harm or death to himself. So Don has to establish that state of mind. Where is he going to get it from? Here. Don's testimony included that his testimony that several other residents of the boarding house where they lived told him that Vic was out to get him and was going to kill him. So Don heard these people at the boarding house saying, Vic's going to get you. And that is not being offered to prove the truth of the matter asserted, that Vic really was going to get him. It's being offered to show its effect on Don's mind. And Don's mind thinks, and when Don heard that, plus Vic was getting the best of the fight, Don will argue, I reasonably believe that Vic intended to kill me and I couldn't let him do that, and so I killed him. Self-defense. So that's an example where the statement of the other boarding house people is offered for its effect on the hearer, not for the truth of the matter asserted. So that's how these problems, that's what you need to know about this area of law, this state of mind stuff. The three biggies that I mentioned: declaration of your own state of mind, you cause the state of mind, and finally where circumstantial evidence leads you to conclude what the state of mind is. Now actually there is one last issue I want to call to your attention, and that is FRE 803 sub 4 instead of sub 3. Now 803.3 deals with declaration of your present state of mind. 803 sub 4 deals with a hearsay exception which applies when you go to medical people for treatment or diagnosis. And when you do that, you're almost sure to talk to these people about past conditions. Yesterday my leg hurt. Last month my stomach hurt, and so forth. And so there's a lot of historical information provided in that setting. And the hearsay exception, if you qualify under 803.4, does apply to historical statements about your health, whereas 803.3, it has to be the things that you remember really don't qualify under that exception. So keep that in mind. The historical material, if you're looking for medical care, then what is said to the physician that is relevant to medical care about your medical history, pain, and so forth, does qualify under that exception. That's the end of this lecture.